All right, thanks for coming out this morning. Let me introduce our speaker. Our event, our talk, is about freedom from religion or freedom for religion, rethinking the First Amendment's protection for religious liberty, a timeless and a timely topic in view of some recent developments in American constitutional law. Our speaker is Vincent Phillip Muñoz, who is the Tocqueville Associate Professor of Political Science and Concurrent Associate Professor of Law at the University of Notre Dame. He is the founding director of Notre Dame's Center for Citizenship and Constitutional Government. And he writes and teaches across the fields of constitutional law, American politics, and political philosophy, and has published more than one book on the question of religion and the Constitution and the founders' thought. So without further ado, let's welcome our speaker.
Thank you. Yeah. Good morning. Can you hear me okay? It's all right? Okay. I'm delighted to be here with you. I spoke at the University of Nebraska, Omaha 10 years ago. I must have said something not so kind or didn't give a very good lecture back then because it's taken 10 years to get re-invited, so I'm pleased to be back. I'm from Seattle, and I live in South Bend, Indiana now. I absolutely love Omaha. I think when I think of America, I think of actually Omaha, and I have family here, so I've been here, I'm here often. So I'm especially pleased to be with you. Especially pleased to be sponsored by the Jack Miller Center too. It's a great organization. If there's any graduate students in the room, they do if you're interested in American history, American civics, American founding, it's a very good organization that supports work in that area, and so I'm pleased to learn that they help co-sponsor this talk. Also very pleased to be here at the invitation of Dr. Holloway, who his work in American political thought and on Hamilton and Washington is well, you have one of the nation's leading scholars on Hamilton and Washington and the early founding era. So I'm especially pleased to be here at his invitation. Okay, so the subject of my talk this morning is religious liberty, and the question I'm posing is, does religious liberty primarily mean freedom from religion or freedom for religion? And to begin to answer this question, I want to start with a couple recent cases. This is just a case from a few months ago, handed down. The Supreme Court made a decision in Kennedy versus Bremerton in June, this past June. So Coach Kennedy, starting with his first game in 2008, he takes a knee after his public school, after his team's football games. He'd been doing this for a year. So after the game ends, he goes to the 50-yard line and takes a knee in prayer. You can see him there. I think one picture is him actually at a game, and the other is him before the Supreme Court. So he'd been doing this since 2008. In 2015, his school district found out about his prayer practice and insisted that he needed to stop it. The way they found out about it was another coach, just in casual conversation, mentioned it to a school district official, saying, "Oh, it's great that the coach is allowed to pray, and he's open to other people praying with him." When the school district found out about this, they immediately tried to put a stop to it. Coach Kennedy didn't much like his district's demands. There are some factual ambiguities in the case, but the end result was, despite the insistence of his school district officials that he stop his prayer practice, he continued to pray in front of his students on the field, which led him to being suspended and then eventually discharged from his position. The coach then sued for, wrongful termination, and his case made it all the way to the Supreme Court. Again, the decision being handed down just a few months ago in Kennedy versus Bremerton School District. Okay, let me talk about another case as well. You might remember this. This got a lot of attention in the news. This is in 2018. The Supreme Court heard a case brought to it by a gentleman named Mr. Jack Phillips. Phillips, you might remember, was a Christian cake artist. That was his term, a cake artist. He owned a shop called Masterpiece Cake Shops. Any of you married in here? Okay, just a few of you. And for your students, what do you think a wedding cake costs? Give me a couple numbers. $200? $500? It's in the thousands. I didn't know this either until I got married. My $250 budget wouldn't have bought a piece of cake, it turns out. So this guy designs custom cakes, wedding cakes, and these cakes can run in the thousands of dollars. He's a cake artist. Phillips refused to design a cake for two gentlemen, Charlie Craig and Dave Mullins. They sought to have a cake designed for their same-sex wedding party. Phillips said he refused to design the cake on account of his Christian beliefs. So Craig and Mullins, the gay couple, filed a discrimination complaint. The Colorado Civil Rights Division, with the Colorado Civil Rights Division. That division found that Phillips violated Colorado's non-discrimination law, which prohibits, at least among places of public accommodations, prohibits discrimination against same-sex couples. So the Civil Rights Division ordered Phillips to change his business practices. Phillips appealed the judgment, and this case too wound up before the Supreme Court. So Kennedy versus Bremerton and Masterpiece Cake Shop versus Colorado, they're noteworthy insofar as they made it to the Supreme Court. But they're also typical insofar as they exemplify the core divisions in America regarding religious freedom and the Constitution. To speak in broad terms, the left, or the progressive left, emphasizes freedom from religion, especially freedom from the influences of traditional religious sexual morality. Leading progressives contend that Coach Kennedy should be prohibited from praying, at least in front of students, lest his prayers coerce students on the team. When state officials endorse religion, especially in the context of a public school, they can psychologically pressure students. And this unjustly encroaches upon the liberal conception of individual moral autonomy. To preserve autonomy, progressives also contend that we must overcome long-standing forms of oppression, including religious condemnation of non-traditional sexual practices. So whereas public school kids must be secured from unwanted prayers, the market must be made secure from invidious discrimination. The right to be free from religion means Coach Kennedy must be prevented from praying, at least in the context of a public school or football game, and Mr. Phillips must be made to design the cake. Social conservatives, by contrast, say religious freedom is the freedom to be religious, especially to live out one's religious convictions in the public square. So religious liberty, most conservatives say, means that Coach Kennedy has a right to kneel down in prayer, and that Mr. Phillips has a right not to bake the cake. So is religious freedom freedom from religion or freedom for religion? One thing that's interesting in this area of law, both sides appeal to the founding fathers for support. Progressives tend to say that the founders gave us a secular constitution. The Constitution does not acknowledge God or the Bible. The First Amendment, moreover, prohibits the establishment of religion, which Jefferson said creates a wall of separation between church and state. Conservatives counter that the founders embraced religion in their political acts. There's many examples one could take, but consider George Washington's first inaugural address, which is, for the most part, if you go back and read it, or even better, go back and buy Professor Holloway's forthcoming volumes on George Washington's collected works. When you buy those volumes and read his first inaugural address, you'll find that most of it is a prayer. Conservatives also note that the First Amendment declares that Congress shall make no law prohibiting the free exercise of religion. So whatever the Establishment Clause means, conservatives claim that the founders' speeches, deeds, and other constitutional provisions reveal that they did not mean to purge religion from the public square. I should pause here. I should start presuming everyone is a constitutional studies student, which might not be true. The First Amendment begins, Congress shall make no law respecting an establishment of religion, that's known as the Establishment Clause, or prohibiting the free exercise thereof. That's known as the Free Exercise Clause. So these are both provisions of the First Amendment. Okay, so given these seemingly contradictory commitments, freedom from religion on the one hand and freedom for religion on the other, what are we to make of the First Amendment's protection of religious freedom? Did the founders offer a coherent understanding of religious liberty, one that we might recur to today in our increasingly religiously and morally pluralistic nation. My argument to you today is that the founders do have something to teach us, but the lessons they offer do not neatly fit into our current political categories. Freedom from religion and freedom to practice one's religion are both, in fact, part of the founders' understanding of our inalienable natural right to religious liberty. But I'm going to argue before you that conservatives and liberals both exaggerate their positions. Okay, so this is what I'm going to try to do. I'll talk about the founders' understanding of the natural right to religious liberty, the Supreme Court's understanding, and then I'll contrast the two and try to explain how the founders might address some contemporary church-state debates. I should just say, what I'm going to try to do with you in about 30 minutes takes me 3 to 4 weeks to do when I teach this material. What does that mean for you? It means I'm just going to assert a bunch of things. When your professors read your papers and they say, this is an assertion, not an argument? That's the comment I write the most on my student papers. I'm going to do that. So I'm just going to assert a bunch of things. If you want more evidence or arguments, just ask me. Okay? I realize here I'm to teach, to give a lecture, not teach a semester class. Okay? All right. So I don't think we quite understand the founders because we've forgotten their basic principles of government. The founders, like us today, used the language of rights, but their understanding of rights, at least I'm going to argue, is far deeper, philosophically richer, and I think more integrated with the notion of duties than our typical understanding today. We tend to think of rights as interests, especially important or necessary interests. We say health care is a right or freedom of speech are rights because we believe bodily health and the freedom to express one's opinions are necessary to live a decent life. But at the same time, our legal practice recognizes that even fundamental rights, such as freedom of speech, can be limited or curtailed if compelling state interests are at issue. Compelling state interest is a legal term that the court uses to limit rights. So how can we say we have rights and rights are trumps, but we can limit them at the same time? I think that language is confused. We say we both have rights that can't be trumped and we can limit rights because we think rights come, at least our most important rights, we think they come from the state. We think a good government grants extensive rights to citizens because we believe the role of government is to satisfy our collective will and to help us gratify our individual desires. But the extent to which any particular right might be available has to be balanced against other rights and other state interests, a process that it is administered in the final analysis first by the administrative state and then by the federal judiciary. There's much to be said for this conception of rights, but it's not the founders' conception of rights. At least it's not consistent with their understanding of natural rights. And so that's what I want to talk about, because they called religious liberty a natural right. Natural in this context means that our rights lie in our human nature, not that they're created by government. The natural right to religious liberty, in other words, is not created by government. A just government recognizes it. The founders held that our natural rights are endowed by our Creator. The founders also held that our rights are not opposed to our duties. Indeed, our duties to the Creator are why we have rights among men. James Madison, the most philosophically articulate founder on these matters, stated the matter most clearly, and you have a quote here from him. Because we are first and foremost children of the Creator, Madison said, our first allegiance is always to God. Our duties to the Creator lead to rights among men. The political institutions we create and the civic obligations we impose accordingly must recognize our pre-existing duties and therefore our inalienable natural rights. Our politics must remain limited in its aims out of respect to and deference to higher claims of religious authority. We have a political right to religious liberty, again, because we have a more sacred and sovereign duty to God. For the founders, then, the right of religious liberty imposes limits on state authority. The First Amendment states that Congress shall make no law prohibiting the free exercise of religion because political authorities cannot legitimately directly exercise authority over religious exercises. Congress, and I mean, if what I'm about to say doesn't make sense to you, don't worry about it, but Congress and the states via incorporation, if you've had a constitutional law class, you'll know what incorporation is. So incorporation of the First Amendment to apply to the states via the 14th Amendment. So Congress and the states lack legitimate authority to regulate any aspect of our religious worship, including by whom, how, where, and when it is performed. If that's confusing, the takeaway line is government officials have no authority to punish individuals for improper worship, right, or for failing to worship, and they can't command us to worship. How or why or where or when we worship is no business of government. That's what it means to possess an inalienable right. We don't give authority to government over the exercise of our worship. And this, just incidentally here, is, I often get the question, how does the First Amendment, religious freedom, how does it protect atheists? Well, in a way, the surest protection is for atheists, because it means government can't make you pray or make you go to church. I mean, that protects everyone, but it especially protects the non-religious. So another example here, so what is an establishment of religion? Think about licensing, right? I mean, how many of you want to go to law school? Okay, to go to law school, you have to have a law license. To get married, you have to have a marriage license, right? To be any of you want to be teachers, a high school teacher or grade school teacher, you have to get an education license. I mean, one of the few things you don't have to get a license to do, which is interesting, is to be a college professor. Turns out anyone can be a college professor. We don't license that at all, right? So here's a question. Can we license preaching? Should a preacher have to go to the state to get a license? I mean, you can't even get your hair, cut someone's hair without, you have to have a cosmetology license. Anyone have a cosmetology license? Right? It would be illegal for me to, I'll do a lecture and then I'll give haircuts afterwards. I can do that. I can do the lecture, but not the haircuts. I'll get in trouble with the State Board of Cosmetology. To get a cosmetologist, I have no idea what it's like here in Nebraska. In many states, it's hundreds of hours of training. Well, what about preaching? I see heads shaking. No. Why can't the state issue preaching licenses if we can license all these other things? And I think your instincts are right. The answer is because we don't give government authority over whom can or cannot preach. It's not a power that government has. To put it in legal terms, government lacks jurisdiction over religious worship and the exercises thereof. That's why government can't establish a religion. So the Establishment Clause and the Free Exercise Clause together articulate fixed limits on governmental authority. And they do this to safeguard our natural right to religious liberty, which again is inalienable. That is, we don't give it up. So just as government cannot regulate religious practices, it cannot legitimately license preachers or employ religious ministers as officials of the state, to take two examples of what constitutes an establishment of religion. Are any of you studying constitutional law right now? Oh, good. All right, good. This is even better. So right now in constitutional law, textualism is all the rage. And that means a judge in particular, or anyone who's interpreting the text, ought to start with the text. I should have put the text of the First Amendment up there, right? You can write this down. This is what I would do in class. So write the following down if you have pen and paper. Congress shall make no law. Congress shall make no law. That's how the First Amendment begins. And then you write ... prohibiting the free exercise thereof. I left out the Establishment Clause. Or prohibiting the free exercise of religion. When the founders drafted Congress shall make no law, they understood this to limit what the state can do. And no law means no law. Congress can make no law prohibiting the free exercise of religion or establishing religion, that is licensing ministers, right? No law means no law. It can never legitimately do this because it lacks authority or power to do it. This categorical character of religious liberty necessarily means the scope of the religious liberty right is limited. You can think about it in terms of spheres of authority. When government acts within its proper sphere, religious citizens can be accommodated from burdensome laws, but they have no right to be exempted from those laws. Likewise, if government cooperates with religious institutions to accomplish otherwise legitimate civic ends, that is, when religious institutions are within the sphere of what government can rightfully do, government can partner with religion. But there are certain things government can't do that lie outside the sphere of governmental authority. That's what the founders meant by us having an inalienable natural right to religious liberty. It imposes categorical barriers on what government can do. The understanding I've just laid forth, which comports with the text of the First Amendment and the founders' natural rights understanding, is completely alien to how the Supreme Court understands the First Amendment. So let me turn now to how the Supreme Court interprets the First Amendment. Starting in the 1940s, the court, primarily liberal justices, expanded the Establishment Clause by reading it to prohibit government policies that advance religion, even if those policies pursue an otherwise legitimate civic purpose. It increasingly assumed that the federal government and then state governments via incorporation must be neutral towards religion or between religion and irreligion. Now, liberals also expanded the free exercise in the 60s. This was the era of judicial activism. As I'll explain in a few minutes, conservatives have now become activists on the free exercise clause. But liberals originally ruled that the free exercise of religion means that religious individuals do not always have to obey the law, even legitimate laws, if those religious individuals or institutions find those laws burdensome. This is now criticized by liberals and embraced by conservatives. Okay, let me start with the Establishment Clause. The most famous wall of separation case is a case called Lemon v. Kurtzman. Let me just give you a little background on this case. So this case comes from 1971. It comes from the state of Rhode Island. I'm not sure if you would have had this situation here in Omaha. Rhode Island, the state of Rhode Island passes a law aiding math instruction and science instruction in private schools. Most private schools, the overwhelming majority, 95% of private schools in Rhode Island are Catholic. It's a relatively Catholic state. There's a crisis of Catholic education in the late 60s and 70s. Anyone have any ideas why?
The bill.
What's that?
The bill.
Well, part, perhaps. But what do you know what's going on in the church, the Catholic Church in the 60s, and primarily in the 60s? I mean, lots of changes related to new technologies and everything. Lots of, yeah, please. There's a lot of reform going on, and what's going on? Who think of old movies? Who's teaching in these Catholic schools? Nuns, right? And why were the Catholic schools so excellent? How much do you pay these nuns? Turns out you pay them almost nothing. So if you have an incredibly highly qualified workforce, and these nuns were amazing, and you pay them nothing, it turns out you can have phenomenally good schools, right? This is the dream of every dean, right? But all these nuns start leaving religious life. So all these teachers start leaving. So now how are you going to maintain these private schools? And the people of Rhode Island say, hey, lots of us send our kids to these religious schools, and we want to fund their math and science education. So the state of Rhode Island adopts a program to help math and science education in all schools, including religious schools. We don't need to go into the details, but the basic thing is, look, we'll help supplement the salaries of math teachers. As long as you use the same textbooks that the public schools use, and as long as your math teachers don't make more than the public school math teachers, in fact, I think they had to make a little bit less, we can add a salary supplement. So this is the civic purpose is obvious, to fund mathematical education in schools. Question for the court: can the government fund math teachers in a religious school? And the Supreme Court says no, in this case Lemon v. Kurtzman, because of the wall of separation. And the court says in 1971, all legislation must have a secular purpose. Well, this had a secular purpose, funding math instruction. But it can't, all legislation must also not advance or inhibit religion. Now, truthfully, the court never worried about the inhibition. In practice, you can't advance religion. And the argument was, well, some of these math teachers might be priests, they still might be religious, or they might be Catholic themselves. And teachers could represent the faith, and therefore, even if we're only funding math teachers, those teachers might advance religion. Moreover, giving government money to a Catholic school would entangle church and state, and that's prohibited by the Constitution. This is the wall of separation. So in practice, you must exclude religious schools from receiving government funds. Everyone follow that? And there's all sorts of cases on this. Lemon is just sort of the high point on this. A few other examples. Zellman versus Simmons-Harris. This is a case from Cleveland in 2002. It involves school choice. School choice has been big in the news in various places. Recently, Arizona just adopted this massive school choice. Can religious schools participate? These are vouchers for kids. You give the parents a voucher, and the kid can go to any school using government money, including private schools and including religious schools. It was a 5-4 decision. The Supreme Court upheld this. The 4 dissenting justices said, no, even if government dollars go to private schools, you must exclude the religious schools because of the wall of separation. That's freedom from religion. Trinity Lutheran, this is a more recent case. This is from Missouri. On like a football field, when you see all the black stuff flying up, they tackle someone and all this black stuff. You can see it on the. What is that black stuff? Do you know what it is? Yeah, it's tires. It's recycled tires. So it turns out tires are. What do you do with a tire after you drive 50,000 miles or whatever? Anyone burn a tire before? It's environmentally, they're a problem environmentally. So they figured out you can grind up these tires, and then you can use them in football fields and in playground surfaces. The playgrounds, and they're soft, the ground's soft, kind of spongy. Those tires, right? So Missouri has a scrap tire program where it's both environmentally, and they're trying to improve playground safety. The state says, look, if you have a playground, you need it resurfaced, you can participate in this scrap tire program for playground safety. And this Trinity Lutheran, which is a school, has a playground. They say, well, yeah, we'd like to participate. They put in an application. Their application is found successful. It gets all the way to the Supreme Court. Can government dollars fund the playground resurfacing at Trinity Lutheran School? Now, the Supreme Court upholds it. I think it's either a 6-3 or 7-2 decision. But the 2 dissenting justices say, Justice Sotomayor writes, no, that violates the wall of separation. You must exclude religion, even a playground, a Trinity Lutheran playground, from receiving government dollars because of freedom from religion. Okay, so that's the Establishment Clause and the court's approach to the Establishment Clause. Okay, what about the Free Exercise Clause? I mentioned that it was in 1963 in a case called Sherbert versus Werner, the court expanded for the first time the free exercise protection. Let me tell you a little bit about this case. Adele Sherbert was a Seventh-day Adventist. She worked in a textile factory in South Carolina. At the time, textile factories operated 6 days a week, so the work week was Monday through Saturday. Mrs. Sherbert had an accommodation from her employer. She only had to work 5 days a week because her Sabbath was Saturday. The textile factory changed ownership, and the new owners came in and they told Mrs. Sherbert, you have to work 6 days a week like everyone else. So she doesn't show up for work. She's a little old lady. She's been working for the factory for 35 years. She doesn't show up for work. They give her a warning on a Saturday. She keeps on not showing up for Saturday. She's not going to work on Saturday. So they fire her after 8 weeks or so. She files for unemployment compensation from the state of South Carolina. her application is denied. And the state of South Carolina says, look, you only get unemployment compensation, unemployment insurance, if you're fired without cause, but you were fired for not showing up for work. So you're fired for good cause. You're not eligible, according to the state rules, for unemployment compensation. So she files a federal lawsuit, not against the textile factory owners, but against the state of South Carolina. And she argues, my being denied unemployment insurance encroaches my exercise of religion. And the Supreme Court agrees with her. And they say, right, the denial of unemployment compensation is like fining her for her religious practice. Because she wanted to practice her religion, she lost out on a governmental benefit, and therefore her First Amendment right was encroached. Now, presumably, if Mrs. Sherbert just wanted to go to the Clemson football game on Saturday, she would not get her unemployment compensation. Though if anyone's been to Clemson, there's a temple, there's worship, right? There's Saturday worship, all right? And there are gods, and there's Satan, and right? If you're a sociologist, it looks awful like religion. But freedom for religion means Mrs. Sherbert doesn't have to work or gets her unemployment insurance, but the Clemson football fan doesn't. She gets an exemption from the law, even though the law is perfect. The law didn't say anything about religion. It's just trying to prevent people from getting paid for not working. Everyone follow? Okay. The test the Supreme Court comes to adopt is called, again, the compelling state interest. Religious people get an exemption from burdensome laws unless there's a compelling state interest and the government employs the least restrictive means to advance that interest. So one other quick example, famous case called Wisconsin v. Yoder. This is from the state of Wisconsin. Amish kids usually Amish withdraw their kids from schooling after 8th grade or around then. But Wisconsin had a mandatory school attendance law. So in Wisconsin in the 70s, you had to go to school. There's no homeschooling allowed. You had to go to school until you're 16. Amish withdraw their kids from school at the age of 14. So the superintendent of public schools was fining the parents of the Amish kids every day the kids missed school. Do they have a free exercise right not to go to school? If you ask, why do the Amish withdraw their kids from school? Well, it's part of their religious beliefs. You can also, for the students, think of everything you learned your freshman year in high school. Think of all the morally corrupting things you learned your freshman year in high school from your friends. That's why the Amish parents want to withdraw their kids from school. It might be plausible. So do the Amish kids have a right not to go to school? The Supreme Court says yes, under this approach. This is the exemption approach, okay? All right. As I said, this exemption approach was first adopted by the court liberals. But last year, in 2021, it's now the court conservatives. So in a case called City of Philadelphia versus Fulton, it was Justice Alito. I have to back up. I'm sorry, I skipped over something. This exemption approach was narrowed in 1990 by Justice Scalia. Ever since, court conservatives have been complaining. And last year, in this 2021 case, City of Philadelphia versus Fulton, Justice Alito, Justice Thomas, and Justice Gorsuch, so arguably the three most conservative justices, they called for the court to go back to the exemption approach. It looks like there's 5 votes, maybe 6 votes to go back to the exemption approach, though it hasn't been done yet. Okay? All right, so that's freedom. Freedom from religion means religious institutions and organizations and individuals can't receive government dollars, right? Freedom for religion means religious individuals like Mrs. Sherbert or the Amish don't always have to follow the law, according to the court. Okay, what's the founders' understanding? Let me start with the wall of separation. The founders' philosophy, I think, would lead to a much more narrow approach, I would say even a more common sense approach. If a government public policy pursues a valid civic purpose And if religious individuals or institutions qualify to participate on non-religious criteria, then religious individuals and institutions shouldn't be disqualified on account of their religious character. The founders' approach, unlike the liberal Supreme Court approach or the wall of separation approach, would not read the Establishment Clause to mandate discrimination against religion. So if Catholic schools do a good job teaching math and you can figure out a way to fund math teachers in Catholic schools, the state could do it. If the state has a program to make playgrounds safer, you can make religious playgrounds safer too. This is an equality before the law principle. And I think that same equality before the law principle can be applied to the free exercise clause too. But here the result would be resisted by many conservatives, not liberals. Right? So the founders, again, have a narrower view of religious liberty. If the government pursues a legitimate law, that is, it pursues a legitimate civic purpose, the founders would hold that religious individuals have to follow the law just like everyone else. There's no natural or constitutional right to be exempt from a law. Right? Now, we the people can exempt religious individuals or other individuals from the burdens of the law. For example, for military service, we've long exempted religious students or conscientious objectors, including pacifists. But that's by legislative grace, not by constitutional right. The founders' approach would say there's no constitutional right to be exempt from the law. I think church-state issues are at the forefront of our culture wars, in part because it's easy to see the unfairness of each side's position. Court liberals have sought to prevent religious individuals from participating in our civic life on equal terms. I think they unjustly penalize religious citizens to advance an exaggerated notion of freedom from religion. Court conservatives seek to exempt religious individuals from the civic obligations of following duly enacted law. They want to privilege religious citizens to advance an exaggerated notion of freedom for religion. I think the founders' approach would be much more minimal. It certainly wouldn't satisfy everyone. Those on the left would have to learn to accept that freedom from religion means that one cannot be coerced to go to church, not that one can eliminate religion or the presence of religion from the public square. Conservatives would have to accept that religious freedom only means that government cannot impose targeted disabilities on religion, not that religious individuals are exempt from laws they don't like. This more modest approach to religious liberty, I think, would probably satisfy no one. It would necessarily emphasize legislative compromise. It would downplay the role of the judiciary. It would especially downplay the role of special interest law firms, powerful interest groups on both sides of this issue. Religious and non-religious citizens would have to learn to get along better and attempt to work together to adopt laws that in justice can apply to everyone equally. Social conservatives would have to focus on preventing laws they find oppressive, not on getting exemptions from them. It's certainly possible that such an approach would only inflame our political disagreements, that religious and non-religious citizens are so far apart today that basically both sides just want to defeat the other side. Everyone wants to advance vigorously their own conception of what is right and good and make the other side succumb to it. But I don't think that winner-take-all approach has worked. I think the founders offer a different approach that focuses on equality before the law. Okay, let me return, I should conclude here. Let me return to those early cases I mentioned. What would this approach, this equality before the law approach, mean for the cases I started with? Well, it would mean that Jack Phillips, the owner of Masterpiece Cake Shop, would not be constitutionally exempt from general non-discrimination laws. If we the people, it's the people of Colorado in this case, if the people of Colorado decide that those who run a business like Masterpiece Cake Shop cannot choose what customers they will or will not serve, then all business owners would have to follow those rules, including Jack Phillips. If religious conservatives think that Mr. Phillips should not have to design a cake for a gay wedding, they would have to make the argument and attempt to persuade their fellow citizens that non-discrimination law should not be extended to same-sex couples. They could appeal to their narrow religious convictions, Or alternatively, they might appeal to more general convictions about freedom of association or the rights of business owners, property rights. They might even try to make common cause with progressive business owners and say, look, if you own a custom-made t-shirt printing shop or a restaurant, and you're a progressive and don't want to make custom-made t-shirts for the church or cater the church barbecue that you disagree with, you shouldn't have to do that either. In short, if religious citizens think laws would be oppressive when applied against them, they would have to become more political and less legal in an attempt to persuade their fellow citizens on why such laws are bad. If this sounds familiar, this is the argument of James Madison in Federalist 10. Okay, what about Joe Kennedy, the football coach, in his prayer after football games? Well, we'd have to ask, does the school district generally restrict coaches' expressive behavior after games? Well, the answer is no. Well, if they don't generally restrict coaches' behavior after games, you can't target religious exercises. So imagine that Coach Kennedy, took a knee to protest social injustice. Could he do that? Well, if he can, then he certainly can take a knee to pray. Right? Religious freedom means you can't target religious exercises. It doesn't mean more than that, but it certainly doesn't mean less than that. So my argument is that, at least for the founders, religious liberty doesn't mean primarily freedom from religion or freedom for religious individuals to be exempt from the law. Religious liberty means that a certain realm of our natural freedom we withhold and we don't extend government jurisdiction over it. Religious freedom means that all religious citizens would be treated like all citizens, equal under the law. It means that government can't target religious exercises. Again, government can't target religious exercises because government doesn't have that power. Whether we should follow the founders today, and obviously I've tried to make the case for him, but I haven't really tried to persuade you. We can't decide whether we should follow the founders if we don't understand them. So the one thing I've tried to persuade you of is that the founders are worth listening to. They have arguments that we can learn from. Even if we don't adopt the founders' approach, they can and should inform our deliberations about what we ought to do to protect our first freedom of religious liberty. Thank you very much. I'm happy to take as many questions as we have time for.
Yeah, thank you. And we do have time for questions. For technical reasons, if you have a question, I would like to bring you the microphone.
Just
so
do me a favor
I'll
and
pass it
stand
around.
up and introduce yourself and tell me who you are so everyone knows. Yeah.
All right.
Hi, I'm Sequoia Snaketail, graduate student for political science. So my question concerns the wall of separation. So I get my tuition funded through the GI Bill. However, I can go to a religious institution. How does that fall under?
Yeah, did everyone hear? So if your tuition is funded by the GI Bill or some other scholarship, can you go to a religious institution? And you say, I don't know the GI Bill rules, but you could. Yeah. In the court's jurisprudence has made a distinction, for the most part, between college students and primary or high school students. The reasoning for the distinction is the court has said, well, college students are less immune or more immune, less susceptible to coercive pressures. So colleges can do things that college students are, you can use government money at colleges in ways you can't at lower levels of school. I mean, there are all sorts of political interests involved there as well. They're probably obvious to you, but there are very powerful interests against government money going to religious high schools and primary schools. But there's think of state employees. State employees who teach at the primary and high school level see religious schools as a competition in a way that colleges really don't. So the answer is, the truth of the matter is probably more political considerations, but that's the court's jurisprudence. There's one exception to this. It was worth noting. There's a kid, Washington State, my own state, had a scholarship for low-income students. You could go to any school in the state. And so a kid went to a private evangelical school, and the money, he got like, I think $2,500 from the state of Washington. It's very minimal. And he was told, he was a double major in business and pastoral studies. And the name of the case is Locke v. Davey. And he was told, if you declare the pastoral studies major, you lose your scholarship. You can take all the classes, you just can't declare the major. And this kid, he's studying to become a pastor who wants to be responsible, with his church's money. That's why the business. So he declared the major and he lost his scholarship. And he got it all the way to the Supreme Court. And the question, his argument was, well, I lose the scholarship if I declare this religious major. You're penalizing me on account of my religious studies. And he actually lost that case at the Supreme Court. Ironically, his whole experience led him to leave training for the ministry, and he went to Harvard Law School. So now he's a lawyer.
Hi, my name is Simon Pinkerton, and I'm just a freshman on the poli-sci track. I'm curious because the founding fathers were obviously very politically influential when they started. Many of them were the presidents and appointed the Supreme Court judges. So how do you think we got from their argument of how the constitutional right for and from religion, how do you think we got from there to the current understanding on how that should be done?
Yeah, no, that's a really, first of all, I think it's terrific you're here at a lecture being a first-year student, so thank you for coming. That's a long story. And a lot of it is path-dependent, meaning the first cases started us down a path, and that because precedent is an important doctrine, not an all-important doctrine, we've learned, but an important doctrine in constitutional law, the path you start going down, you tend to go down to in the law. So you'd want to look at the early cases. And the early cases here are in 1947, this wall of separation case on the Establishment Clause. It's actually quite interesting. Recent historian, so this case was involved from New Jersey. Can you reimburse the bus fare for parents who send their kids to a Catholic school? The reason, there's no school buses at the time, right? Kids would take the public buses. And why does the state want the kid on buses instead of walking to school? What's the state interest? Safety, right? You'd rather have the kids, especially in the winter, it's dark and everything. So they're like, look, put your kid on the bus and we'll pay the bus fare to facilitate you putting the kid on the bus. And it gets all the way to the Supreme Court. Can the state pay? And this is where the wall of separation decision comes down. And we now, judicial biographers, no one really cares if you pay reimbursed bus fares. But the judicial biographers have uncovered notes. What some of the justices were really concerned about was they didn't want government dollars going to Catholic schools. So it was really about taxpayer funding of Catholic schools. This is at a time when many public schools were effectively Protestant schools. Okay, that's on the Establishment Clause. So you ask, so you get this language of a wall of separation, and then that gets developed over time, culminating in the Lemon case we talked about. The case is a little bit different on the Free Exercise Clause case, and here it was Justice Brennan, right, the great liberal justice of the second half of the 20th century. He just thought, given the growth of the administrative state, that the founders' approach was too narrow. He thought it was wrong that Mrs. Sherbert was being denied her unemployment insurance. She's probably the most sympathetic litigant you can imagine, right? And he thought, look, given the growth of government, people shouldn't be penalized for their religion. Protecting religious actions today necessarily must mean exemptions. It used to be a liberal approach, now it's a conservative approach. That's a very short answer to a complicated question, though, and a very good question.
Hey there, my name's Glenn Weaver. I have a question with school choice, and you mentioned it briefly. A lot of states have legalized school choice. Nebraska has not. You said that I can't remember your argument. Is that constitutional that where the state can give private citizens money to go to Catholic schools? Could you just clarify that a little bit? And do you think that's a future case for the Supreme Court?
Yeah,
moving
sure.
forward?
But first, introduce. Is your son your daughter? Anders. I think it's absolutely terrific. It's a boy? Yes. Thank you for bringing him. Just in general, I think, so I run a program like this, and I'm always encouraging our young faculty or graduate students to bring their kids. So thank you for doing that. Right? We need to be more friendly to families, especially mothers. So I think the school choice decisions school choice is constitutionally protected now, meaning the litigation has been done, I think, in part because there's not a will on the, those who are against school choice probably don't want a case to get up to the Supreme Court because it will come down against them. So I think the constitutional issues, at least at the federal level, are decided. Now state courts could do other things. So whether or not we have school choice programs, again, these are government money going to private schools, including religious schools, depends more on political will than legal issues. Yeah. And there, it's very interesting because the African American community is somewhat fragmented here, right? African American community being very much a core constituent of the Democratic Party, Democrats in general being against school choice, not always, but in general, but African Americans generally being very much in favor of school choice. So we'll see how this issue evolves. The pandemic, I think, tore down some walls against school choice. I'm kind of surprised you don't have more of it here in Nebraska. I would think it would be very popular here, but yeah.
Hi, thank you very much. I'll take this off. A couple questions. One's a bit of a response to a question over here earlier, and that is what happened in between. I'm looking at expansion of the use of the term natural, like the way that it was considered that you would basically have freedom possibly from religion or for. It's because there was a natural right outside of the political process, right? But now, in many cases, that term natural, and I blame, in fact, actually some of the Roman Catholic theologians, like Finis and Grisey and George and people like that, for expanding the use of that term natural. Yeah. And now we see some sort of expansion, right, of what that means, and that allows us, in fact, sometimes to discriminate against people who are doing things that are unnatural. That's back to the sexuality thing. Number two, I was just curious your thoughts about two other cases. One is from Nebraska, where we have a football player named Amir Abdullah for the Cornhuskers who did Islamic prayer, or he, as if, in the end zone, right? And that didn't receive the same sort of treatment as perhaps Kennedy did. And that's one case. And the other case, it's something that's going on in New York State right now, and that is the Hasidic schools received about $1 billion with the understanding that they would do things like teach math and science, but there were no licensed professors, and they weren't teaching math and science. So I'm wondering, what you think of that case moving forward as well.
Okay, good. Well, three. Let me do them in reverse, because yeah. So I don't know the facts of the New York case, so I can't really comment on that case. Assuming it is constitutional, let's just for the sake of argument, you'd still have to use the money as granted. So a constitutional right to be included in a program doesn't mean you're exempt from all the regular requirements of the program. Right, so just as religious groups shouldn't be penalized, at least on the approach I've suggested, shouldn't be disqualified, you're still subject to whatever the rules are. So if they're not following the rules, that seems to be the issue in this case as you present it, they'd still have to follow the rules, right? This is a great problem. We've seen this with a lot of the COVID relief money, right? The widespread fraud and misuse. This is always a danger with government grants, okay? Yeah. So you'd have to have some... Yeah, so the state certainly in funding things has, has a right and perhaps even a duty to impose certain standards. And that's not constitutionally problematic. The position of the religious school would be like, do you want to apply for this money with these conditions? Assuming the conditions aren't requiring you to give up some sort of constitutional right, that's called an unconstitutional condition. Assuming the conditions are, reasonable, the school doesn't have to take the money, but you can't take the money, you can't have your cake and eat it too. You don't get the money and then get to be exempt from the standards, would be the position I've advanced. On the football, I don't know the specific football prayer. I haven't been following Nebraska football recently. It's been a little rough, as I understand it. Look, it doesn't matter what form of prayer you're doing in the end zone or at the 50-yard line. If prayer is protected, prayer is protected. As non-religious speech would be protected too. So you certainly couldn't single out certain forms of prayer.
But
Yeah.
we did choose as a country to single out certain forms of prayer in discrimination of Native American religious rights up until the 1980s or something.
Yeah, well, that wouldn't be constitutional, at least under the approach. We've done all sorts of things that are not consistent with the Constitution. It doesn't justify, we misinterpret the Constitution to justify those bad practices in the past. And then your first question was... natural law. That's a big question. But, in general, the premise of your question was the idea that natural law has expanded. And I know Finnis and Grisey and all those guys. For what it's worth, I'd be in the old natural law camp, not the new natural law camp. But really, we don't really talk about natural rights so much. We talk about human rights. You hear lots of... look at the course catalog here at UNO and look at any course with rights. I bet you there are very few courses with the term natural rights in the title. I would venture there's lots of courses with the phrase human rights in the title. And why do we talk about human rights and not natural rights? Sometimes we mean the same thing, but we've changed our language because we want to get away from nature as a standard. Who grants human rights? They're from government. That was the earlier point I was trying to make. Right? Natural rights are understood to precede government and, as the case may be, limit government, where human rights tend to be thought of as grants from government. So right in the middle.
I'm Leif Price. I'm another first year taking a political science course. I noticed that a lot of these cases and also just the issue in general is very viewed through a Christian lens. And that's just because I think Christianity is the dominant religion in the United States, just in terms of how widely it's practiced and how familiar people are with it. And my question is, do you think that creates any bias? Like, for example, a Christian prayer would be okay, but any other religious prayer would not be okay, or something like that. Do you think that creates any bias?
Yeah, no, that's a very nice question. The short answer is yes, I think that's probably true. To the extent that we've had a predominant religion in our history, right? A plurality of Americans have been Christian, so that's not surprising on the one hand. What I've tried to do is explain natural right principles, which are not specifically Christian at all, right? And you could say the task of the founders set before themselves were to try to articulate principles of justice that would apply to everyone, right? So there's a good example, maybe that gets at your question, from both reflects your insight, but also tries to respond to it, from the founding era. And so the federal Constitution says there's no religious test for office, right? So at the state level at the time, not every state, but most states had religious tests for office. So in Massachusetts, to be the governor or to be in the state senate, you had to be a Protestant. Other states had, so Massachusetts just said you must be a Protestant to be governor. Other states had religious tests for office. Religious oaths for office. So you know how the president takes an oath of office on Inauguration Day? In some states, you had to take an oath that you believed in the Old and New Testament. So a Jew couldn't, in good conscience, take the oath, right? Or you had to there are religious limitations on office holding. And these limitations in practice were almost all Christian. So that sort of reflects your question. Was there a bias in the system? The answer is yes. At the federal level, the framers said no religious tests for office. And the people against the Constitution, the Anti-Federalists, said, hey, there's no religious test for office. That will mean a Catholic or a Mohammedan, a Muslim, could be elected. And James Madison said back to them, and you can read this in the ratifying debates, yes, that's true. If they gain the favor of their citizens, that is, if they get enough votes, they can be elected and should be. Because our civil rights should not be limited based on religious affiliation. So I think, that example from 1789 reflects both your insight, but also the constitutional remedy.
Hi, I'm Joe. I'm actually an international student here from the United Kingdom, so I'm studying political science. I just had a question. I know for the most part today we've been talking more domestic, but I had a question regarding which I think would actually sort of fall under this, and please do correct me if I'm wrong, but there was a global gag rule which I know was introduced by President Bush and then also reinforced by President Trump, which would prevent foreign NGOs receiving US money if they knew that if there was any activities involving, abortion and medical health care. Mm-hmm. I just wanted to know and ask actually from a more of like an international perspective where the sort of law would sort of stands on sort of civil liberties and sort of all that sort of area if in terms of like healthcare, because I know in the US it's very much differs between states and it's obviously very much of a contentious issue, but in other worlds, in other countries and other sort of foreign sort of states, it's a bit more permissive, a bit more liberal. So I just really wanted to know, how does sort of freedom from sort of religious laws like this, if at all, sort of apply to like gag rules like this, whether they can actually do it or whether it's illegal?
Yeah, the first question you'd have to ask is how are these policies, right, these administrative decisions being made, right? Are they based on religious criteria or not? Right. If they're not based on religious criteria, then it certainly wouldn't be a problem. Right. So I suspect the proponents of the policies would say these are not being based on religious criteria. One can have all sorts of good faith arguments, they would say, on why we shouldn't fund abortion from just a dignity of life perspective. Religious people may share that, but you don't have to be religious to share that, I suspect. Yeah.
Hey, I have a question, if you don't
Sure,
mind.
yeah.
You were kind enough to mention
Yeah.
my studies of George Washington, so I
Yeah.
just want to ask you, did the founders all fully understand this philosophic approach to religious liberty, or was there sort of a learning process going on? Because there is a diversity of opinion among them, and the example I'm thinking of that you made me think of by your talk is I know that early on when George Washington was commander-in-chief of the Revolutionary Army, Congress would declare days of worship, and he would pass that along to the Army. And I remember in one set of general orders, he said to the soldiers, you will show up, and you will, with unfeigned devotion, take part. It's like saying, you're going to pray, and you're going to mean it. Yep. That's not totally consistent, I don't think, with the approach you're laying out, or unless there's some version of it that I don't understand. But do you think they're making progress over the period of the revolutionary times, understanding religious liberty to be a natural right? And would that be consistent with that natural right if you're trying to make people pray who are serving in the military?
Yeah. Okay, so everyone understands the question? Professor Holloway is saying, George Washington, the most distinguished, important, thoughtful American ever to have lived, says one thing, and you say something else. That's the question, right?
Well, let me modify the question, because he said other things later on that are much more like what you said. But I'm just saying George Washington in 1777 was capable of saying something like that.
Yeah, that's right. Where I thought you were going to go is there's a famous Supreme Court case from the 1980s, not 1780s, involving Nebraska, Marsh v. Nebraska. So Nebraska had a legislative chaplain. The guy's job, he's a Presbyterian, he had held the position for years, and his job was to minister to your legislature. And the defense of this practice, so there's an official state chaplain paid for with government money. The defense of this is the first Congress, the same Congress that wrote the First Amendment, had a chaplaincy. And part of the defense of that is the first military chaplains were inaugurated by George Washington. And Washington, in his letters, which you will know after you buy Professor Holloway's book, one of the first things he did as commander-in-chief during the Revolutionary War was he wanted a salary increase from the Congress for chaplains, because he wanted better chaplains. And Washington's argument, which is totally understandable, is if I'm going to send these boys off to die, I at least should provide a chaplain for them. So there's a rich tradition of military and legislative chaplains in American history. And Professor Holloway says, if I understand you correctly, you think all this is unconstitutional. And the answer is yes, actually. It's perfectly understandable that we would want military chaplains. It doesn't mean that government has the power to select chaplains. And once we start selecting chaplains, it runs into all sorts of complicated problems. So right now, there are cases percolating in the lower courts and administrative courts on does the government, if it provides chaplains, say in the military, have to provide chaplains for every religion? Does this mean Wiccans or sons of Satan who want chaplains as well? And if you have chaplains, you're going to have to start, government officials are going to have to start deciding who is and who is not a valid religious chaplain. And those are questions we generally don't want government officials asking. Now, if George Washington was making the decision, at least I would be perfectly comfortable with him making the decision. But we have the rule of law and not of men, because not everyone is as sensible as George Washington. So we can't always follow what he did. Well, thank you very much. I mean, the questions were just terrific. And again, I'm so thankful to be here.
Thank you.